So we had a few nice discussions this morning about how standards were cooperative versus collaborative versus different types of standards, de facto proprietary technologies, etc. We talked about licensing, and in some cases, licensing negotiations fail and there are disputes. And we've seen a number of these recent developments, related to matters involving FRAND-assured SEPs in both courts and at competition agencies around the world. So this panel will explore the recent FRAND-related developments in courts across Europe and the interplay with antitrust law and policy in commercial disputes. We'll also hear about how all this relates to some of the recent antitrust guidelines for licensing of IPRs that have been released by some jurisdictions outside of Europe in the last couple of years. So moderating this session is Corinne Wong-Irwin, who joins us from George Mason University's Global Antitrust Institute, and in fact of this week at Qualcomm. We have an exciting combination of panelists as well, so please allow me to introduce Professor Dr. Bornkamp, who is a retired judge of the German Federal Court of Justice. We have Commissioner Nicita from Italian Regulatory Authority, Professor Nicolas Petit from University of Liège School of Law, and Dr. Qishan Zhao, Director of IPR Policy from ZTE Corporation in China. Thank you all, and over to you, Corinne.
I'm just going to turn this mic off. Thank you. No problem. Thank you so much, Kirti, and welcome back after lunch, everyone. Since we're after lunch, I thought we would do a little bit different format than we've done this morning. We'll make it a little bit more interactive. So please, as the audience, just raise your hand throughout the discussion, and let's really continue the excellent dialogue from this morning. So each of the panelists are going to give some brief introductory remarks. However, since each of the panelists want to talk about some very different subjects, I thought that we might break it up a little bit and have some questions following each presentation so that we can sort of stay on that topic. As Kirti mentioned, this panel is going to cover the recent developments in courts and agencies and how that's affecting private arm's-length negotiations. Because this topic could be so broad, I thought I'd sort of frame the panel for the opening remarks. In my life as an academic, I sort of observed that it seemed to me that the courts might be taking a little bit more evidence-based market approach than some of the agencies. So, for example, in the courts, we've seen a recognition that end-user portfolio licensing has efficiencies and is a positive. We've also seen courts say that theoretical concerns about holdup and royalty stacking need to have actual evidence to be actionable, whereas some of the agencies have had more presumptions of harm and sort of special rules. And so I'm very interested to hear from the panelists your thoughts on this as you have your opening remarks and throughout, and we'll go down the line. So please, Judge, get us started.
Thank you, Corinne. I shall start out with some remarks on the judgment in the Orange Book Standard case, which after 8 years you may consider legal history already. The Orange Book judgment was the first decision which set out a roadmap for patent infringement cases once the defendant came up with the so-called compulsory license defense. The situation in Germany at the time was somewhat disturbing. The compulsory license defense had brought many important patent infringement actions to a halt. Everything seemed to depend on what FRAND conditions for a license would be, and alas, nobody had a clue. Unfortunately, there was some misunderstanding as to our judgment. The lower courts, mainly the patent courts in Düsseldorf and Mannheim, interpreted the leeway which the Orange Book judgment seemed to leave to them much in the favor of the right holder. Just a couple of remarks on the case. It was not an SEP case. there was no standard set by an SSO, but rather a de facto standard, at the bottom of the case. There was little dispute as to the defendant making use of the patent. It was quite clear he was making use of the patent. There was no patent validity issue. There had been the defendant had challenged the patent before, but without success. So this was not an issue anymore. There were no contractual obligations involved as to FRAND licensing. The defendant was in a difficult situation from the start because he had started to use plaintiff's patent without asking for a license. So this meant he was in an uncomfortable position before the courts because he was the infringer, he was the violator. The judgment stated that the defendant, after having made an offer for a license, could still take the position that he was not making use of the patent. But the judgment was not entirely clear in this point. So lower courts, some of the lower courts understood the judgment as there would be no possibility to challenge it, to pick up that point, that to claim that he was not actually using the patent. But that was not true. It was quite clear that he could make an offer and still keep the position that he wasn't making use of the patent. So much to Orange Book. Let me make a couple of additional remarks. I know that there have been many cases in Germany so far in the last years, mainly in the Düsseldorf and Mannheim courts, in the Court of Appeal, but no further case has reached my former court, the Federal Court of Justice so far on the matter. But there are many questions of detail which have been discussed in the lower courts and the Court of Appeals in Düsseldorf and Mannheim and Karlsruhe. So I'm not going to go into the details of this jurisprudence, but I'd like to focus on three additional questions. Why is it that standard essential patents are so dangerous? If the question of FRAND could be easily answered, there would not be much of a chance for a hold-up. But finding out what FRAND is really at the core of the issue. And this is the same in the United States as in Germany. To my belief, it's a birth defect of the present system of standardization that standard-setting organizations, when choosing a standard, do not implement a procedure for determining what FRAND is. After all, determining a patent as a standard is a hardcore cartel, which should only be allowed if precautions were taken that the dominant market position created by the standard-setting organization could not be abused by creating a hold-up to competitors. Second point deals with the contractual obligation.
May I just stop you there and ask a question?
Yeah.
So I think that's, so my question is really for you or anyone. Maybe we'll open it up a little, have a discussion on this, then come back to the others' opening remarks. This idea that standard setting is inherently sort of picks winners or confers market power. I know we talked about this a little last night, and I'm interested in your views on the studies like by Dr. Padilla or others showing that as opposed to sort of conferring market power, standardization tends to pick the already best technologies, so that it's sort of a myth that this is a sort of winners getting in a room picking. Competitors getting in a room picking winners.
Well, there wouldn't be that much of a difference when it comes to competition law, to antitrust law. I mean, either it's a de facto standard or it's a standard made by an organization. But of course, the situation we have is that the competitors sit together and choose one technology to be the standard. And in that situation, I think precautions have to be taken for finding out what FRAND is. Or this is just, as long as one doesn't know what FRAND is and there's no way to easily find out, this just leads to the situation of the hold-up. And I think that's the core of the problem, that you give this dominant market position to somebody. I mean, you have the same problem if it's a de facto standard. You still have to find out what FRAND is. I mean, because as I said, or as I will say in a moment, in competition law, this is the core of the problem. It doesn't have to be a contractual obligation, but it would be the same under competition law, antitrust law, that if you have a dominant market position, you're under German, European competition law, you're obliged to supply the customer with goods, and you cannot, you have to enter a license agreement. And of course, the conditions of these license agreement, which you have to grant to a license applicant, is they have to be fair and reasonable, and they have to be non-discriminatory. So we are at the same point of asking what FRAND is. So
I think it's great, and maybe we can open it up to the panelists to discuss and then come back to some other issues. Did others have thoughts on this?
Yes, of course, relative to this latter point, I think we have, different trade-offs going on there, okay? Because on the one side, it is true, and I agree that you have competitors discussing in a room over a standard, which, in a sense, this could raise potential anti-competitive problems, which, however, somehow they are compensated by the fact that you are choosing standards precisely among competitors who, in a sense, they agree on sort of platform over which they could further contribute on the one side. And at the end, it is done on the overall welfare of consumers and industry. It has been recalled in the previous section that there is a huge debate in economic literature on path dependency and on the selection of the efficient technology over time. We have several cases in the history, in our technological history, for which the bad standard in terms of quality has been selected precisely because expression of market power. We have the Betamax cases versus some other cases. So there is not only the today's benefit of actual consumers, but also the potential benefits that could come from creating or selecting a good standard today relative to bad standard that eventually could even monopolize or select a bad technology. Of course, it's not easy to assess whether a technology or a standard is better than another one every moment in time. But this is precisely the reason why I think it's useful to have the industries talking together with conflicting interests, because at the end, you can have a higher probability that the selection of the standard somehow is going in order to support the evolution of the market in the relatively better technology standards at a certain point in time. So it is true that there could be some anti-competitive concerns, but on the other side, since you have many stakeholders in the same room, it is important that they can select the good standard. One point and I will come back on this, that it has also been mentioned in the previous section, it depends whether the company that is selecting or inducing a standard is or not vertically integrated in different markets, because this can raise different incentives also ex post. So I think one important point to distinguish is whether the SAP are or not vertically integrated and in which kind of markets. So what kind of interest they have.
Yeah, thank you very much. It's the beginning of the academic year in universities in continental Europe, and I often tell my students competition law is a gray area discipline, and students often look at me with concern Come the end of the year, they're even more concerned. They think they know nothing, and they're not sure they're employable on the labor market. What is quite clear in today's competition law, and I'm saying that probably 15 days after the Court of Justice issued a very important judgment in the Intel case, is that any duty to deal or source of antitrust liability is contingent on proof of harm to competition. And what I want to say here is the court has sort of taken a very long journey to admit that principle in areas like abuse of dominance, but it now seems very clear from what it says that harm to competition is an empirical question and not something you can suppose categorically. And that applies to duties to deal in as much as it applies to the other areas of unilateral conduct, things like rebates, incentives, and so on and so forth. And that would tend to qualify the assertion that a dominant firm has a duty to supply goods to any and every market because it's dominant. And that would also call into question the idea that in the IP field, a patent owner that refuses to supply a non-competitor is guilty of unlawful abuse of dominance because there's no competitive relationship in that refusal to supply setting. But maybe my dean needs to cut the competition law course if it's not a gray area and it's just black and white categorical principles. So that's my submission.
Okay, first of all, I want to give some introductions about what is Chinese courts and industries do in the past 2 years, and then I will try to answer your question. Okay, as for Chinese courts, we know that in the 2016, the Supreme Court of China issued a new interpretation of patent infringement law. And in the Article 24, then the Supreme Court provided some provisions about how to deal with the patent infringement cases related to SEP. The Supreme Court requires the courts to analyze the two parties' subjective force in the litigation to determine whether or not to issue an injunction. It clarifies that this problem of issuing an injunction should be resolved under the scopes of patent law or the tort liability law rather than under the competition law. Since Article 24 only provides general rules about the SEP injunction, this year the Beijing High Court has issued a new guidelines for the patent infringement determination and gave some specific explanation about how to find out the FRAND liability of the SEP holder and how to determine the unveiling of licensor or licensee. Also, in this year, the Beijing's IP Court has issued an injunction to the SEP owner in the case between the Irocons and Sony. So we can see that, as for Chinese courts, they try to figure out the distinctions between patent law and competition law. And the interpretation of Supreme Court and the guidelines of Beijing High Court just set up a special injunction defense for willing licensee. And the base of that is the principle of bona fide, other than any reasons from the competition law. So I think that the view of Chinese court is that maybe a behavior is not FRAND, but it is far from that it definitely disobeys the competition law. And most of the disputes about SEP's patent infringement case related only to some private disputes between the two negotiation parties. Still, that is why the court wants to resolve such kind of dispute under the patent scope. And as for the Chinese industries, we see that this year, on March 23, the Anti-Monopoly Commission published a nearest draft of anti-monopoly guidelines on abuse of intellectual property right. And there are two very important articles in that draft. One is Article 13, which listed several factors that should be taken into consideration for the agency when it analyzes whether ACP's holder has a dominant market position. It means that nowadays in China, the authority no longer assumes that one SCP is one related market, and the owners of the SCP definitely hold a dominant market position. That is very important. And another important regulation is Article 26. In this article, it says that an SCP holder with a dominant market position may use injunctive relief as a tool to force the licensee to accept its unfair high royalty or other unreasonable license terms, which may cause the attention from the agency. So it says that in this draft, seeking injunction is not an independent anti-monopoly behavior. In fact, it only calls attention from the agency only when it used as a tool to perform another anti-monopolistic behavior. So my answers to your question is that nowadays we can see that the court in China and the agency are very careful about the SCP's cases, and they not assume that this kind of dispute related definitely to the competition. And even the agencies ask for some more evidence about the hold-up problems or the reverse hold-up problems like that. So I think that is what has happened in China.
Just, raise your hand high so I can make sure to see you. Yes, way over there.
Professor Borknam, the question is for you, but I would appreciate answers from everyone on the panel. I didn't understand when you were saying that because FRAND isn't known. My understanding is that once engineers from throughout the industry have come together to agree on the tens of thousands of technical solutions that go into a standard, that the FRAND agreement between the invention company and the standards development organization enables the bilateral negotiations between the licensor and the licensee. So I'm not sure what you meant by FRAND can't be known or that FRAND isn't known.
The contractual obligation only says that the one who gets the standard is obliged to hand out licenses at FRAND conditions, but it doesn't spell out what FRAND in detail is. I mean, it's in the United States. I think the standard-setting organizations are very much afraid of the antitrust agencies because they would think it could be a price fixing or something. But so they never say what FRAND is in detail. They just say FRAND. You're obliged to hand out licenses at FRAND conditions, but it doesn't say under which conditions FRAND has to be found out. But let me just say one remark to what you said about the finding that it's only a way to find out the best standard anyhow. If the standard setting organization would choose the second or third standard in line, not the best, but then it wouldn't be justified to under Article 1013. The whole thing is that the consumer is offered by this standard setting, is offered the best technological standard and not the third or the fourth best. So, I mean, that's a condition from the start that you try to find out the best standard anyhow. But it's a far way from engineers deciding this is the best standard, knowing this is the best standard, and as a competitor in the market to bring this standard to the customer, claiming it's the best. Then you don't. I mean, we may have a chance, but you don't. But when the standard is set, your standard is in the market and it has this dominant position. It's quite a difference. It's an enormous advantage in the market when your standard is chosen as your patent is chosen as the standard compared to what it would be without such a decision.
So I think that my question was more of it, so my understanding is that it is the engineers who are picking and co-develop, the best technology, that it's a myth, and, those have been involved, correct me, but it's sort of, to me, as an academic, I've discovered it was a myth that it was sort of, there's 5 really close technologies, and somehow, someone with more power got theirs in, but there was just as good as another one, that, it's really the best technologies already. And so my question was more about, that, and we heard from Keishan about, in China, and that there's not a presumption of market power, that it's the same sort of effects-based analysis, that we still look at substitutes and for patents, look at the complementarities and different things. So maybe we could hear from other panelists about, how our courts or agencies determining market power, and how should they?
Yes, one point that it's related to that, it's the role of economic analysis in this respect, and particularly the relationship between what you defined, what we define, market power on the one side and bargaining power on the other side. So the hold-up story, it has been mentioned before by Gregory Sidak, came from a totally different literature, the literature on incomplete contracts, and what is astonishing is that normally hold-up in that literature is a behavior, is an opportunistic behavior that normally it is held against the investor. So the problem normally is that when you have to make a specific investment in a context of incompleteness in terms of contractual incompleteness, so in a case in which you have a huge uncertainty over the way in which you can share the rents coming from investment ex post, because once you made investments, you are locked in a given relationship, then the question of hold up is the question of the opportunistic behavior coming from the non-investor side. While here, the question is the opposite. It is the hold up of the investors who, thanks to standardization and the fact that he now is a SEP, in a sense, he has increased ex post the bargaining power in the market. Now, this story needs, from an economic point of view, to be clearly understood, because the point is in which respect and to what extent the bargaining power ex post is a market power, first question, which means is the standard creating a distinct relevant market, and this is an open question also for our colleagues. But second, having a friend doesn't mean that somehow it has been set what is the right price ex ante. So in a sense, there will also be an exposed bargaining between the SEP holders and potential interested third parties. So the question is, for a hold-up to be there, you must not only be locked in the relationship, but there should be some excessive prices relative to some fair prices, which should somehow be set before, which is normally not the case. So I think that from an economic point of view, maybe this definition of hold-up would need some more rich specification, because the only point that we know is that after you have a standard and you are a SEP holder, maybe you have increased ex post relative to the ex ante your bargaining power. But if we just believe that having increased eventually your bargaining power automatically implies increasing market power, so that, for instance, refusal to deal implies abuse of dominance, we are going to take, a route which could somehow generate offsetting effects, because, for instance, we can have hold up also on the non-investor side, because if I am a potential infringer and I know that the SEP could not, for instance, go before the court against me, then I have an incentive precisely to infringe the law. So the hold-up story from an economic point of view needs to be clarified according to specific circumstances regarding market power, market actors, market structure, vertical or not integration among all the stakeholders involved, and so on and so forth. So I agree that there should be no presumption of market power. There could be presumption of increased bargaining power, but it's very difficult to compare the ex ante and the ex post, because it's very difficult to, we'll talk about that later on, to build a counterfactual scenario for which you can precisely assess as a third party what would have been the right price in the first instance.
Okay, sure. So again, I think it's fairly well accepted that in modern antitrust policy in Europe, the question of market power is an empirical question. Yes. And not a categorical question. Even things such as market share presumptions are today sort of in the cemetery of the bad ideas of antitrust thinkers from the 1950s, 1960s. So even in the most sort of ordinary, easy cases of abuse of dominance, you end up seeing the agency trying to substantiate findings of dominance on the basis, and I'm talking here about easy utilities cases, for instance, where clearly the fact that the utility has a dominant position is hardly in much dispute. So it's an empirical question, and the court has been very stubborn in making that point throughout its case law. Now, face that with all the good reasons we know why standards would not causally give rise to market power, things like the repeated interaction of standard setting, the fact that essentiality declarations are spontaneous and done by parties as part of best efforts, but are not sort of objective acknowledgement of market power. Things like the legal system. So your ability to wield some sort of power on your customer is conditional on the existence of legal remedies. And so if you remove injunctive relief, for instance, you end up in another. So it's a spectrum. If you live in a world where injunctive relief is automatically granted, then you can contemplate the scope for a certain degree of power of the supplier on the customer. And I'm not even sure you can call that monopoly power or market power. But so if you remove that entirely and you go to the world where there's no legal remedy, then you have to accept by logic that you're in a situation what that economists call monopsony power. Or maybe not monopsony power, but customer power. And it may be monopsony power depending on the circumstances in the case. There's one judgment, because your question was about the empirical evidence and what the court says. I think there's one case from a German court where it is explained, and it's interesting that not all functions relevant to the implementation of a standard are of equal utility for the customer and of equal value for the supplier. So meaning that some steps which cover technology useful for, say certain marginal functions confer less power, and I'm not talking of monopoly power to the holder of the IP rights. I think it's a judgment in France Brevet from 2015. Now, let me just close here. In Huawei ZTE, which is sort of governing ruling of the Court of Justice on those issues which keep us busy, dominance was not really into discussion. Yes. So the court moved on to discuss abuse and said what we know it said. Not much to find there. We had another judgment 2 weeks ago. Again, the Court of Justice has been very prolific recently in the area of unilateral conduct. related to collecting societies. And the court says, in assessing whether collecting societies' copyrights charge excessive fees on their members or on infringers, you have to take into account the persistence of the problem that you're talking about. It has to be a sort of persistent phenomenon. And what's interesting here, I don't want to look too much and read too much into those words, but the Court of Justice seems to have understood that the idea that the magnitude of the harm to competition that you're talking about has functional relevance for the assertion of antitrust liability. So persistence is a measure of the size of a problem in time. And so the court seems to embrace that notion that it's empirical, you have to gauge the effects. That's all.
So I think so just we're all on the same page, market power is the ability to substantially raise or reduce output above or below the competitive level, for a significant period of time. And at least in the U.S., we don't prohibit, we don't regulate bargaining power. It's market power. And last question on this point, I'm interested to hear how, if SEPs are perfect complements, right, like nuts and bolts, then is there some mitigation of any market power, unlike a normal monopolist that can just set the price without regard to anyone else? I mean, is there really even bargaining power, or, are the implementers, knowing they have to license all these different technologies, going to push back?
If you ask about the dominant market position of a patent holder, the question is always, is there an alternative technology? If there is an alternative technology, then of course the license applicant can go to the other, to try to get the other technology, the license of the other technology, so you don't have a case in the first place. But we're talking, usually we're talking about interfaces or something where the technology is vital to everybody, and that's a clear-cut case where everybody needs exactly this technology. So there shouldn't be much doubt about the dominant market position.
No, just on your suggestion, I totally agree that, of course, when you have complements and each side is making a contribution, then you have a situation of cost-specific investments. And in this respect, there is a sort of creation of a sort of general purpose standards, in the sense that each party is making specific investment in the other technology, and the final result is a standard over which all others, potentially investors, could have access on FRAND terms. So in this respect, cost specificity somehow it's on the one side countervailing power, relative bargaining power, but on the other side is also not defining market power, because it depends whether or not you can define a relevant market attached on this input, because maybe they are just complements for creating some products for which there is a relevant market downstreams, for instance, or upstreams, or whatever. So indeed, actually, also in Europe, we should not regulate bargaining power as such. You know that from an antitrust point of view, we had a long story on, also in the US, on antitrust relative to aftermarkets. And so somehow, when you define market power and dominance, you should refer to some market which has persistence, stability. You have to identify a demand which is stable over time, and so on and so forth. So typically here, in a situation in which you have market power, for sure you have also bargaining power with all the possible stakeholders along the chain of the industries. But it's not necessarily true that if you have bargaining power, then you also have market power. So it depends on the competitive analysis. And one point, just very briefly, is that, for instance, in Samsung and Motorola case, it seems to me that the courts somehow has interpreted the idea of having SEP and FRAND as sort of liability rule, which means that once you are SEP and you have a commitment to FRAND agreements, it is as if, according to those decisions, it is as if any potential third party that is interested in having access to the patent as a sort of liability rule, so a right to access direct without any mediation, just with the only obligation to identify a price to be transferred. While in my view, and according also to the recent decision on Huawei, still, if you are SEP and you have FRAND obligation, your property right is protected by a property rule, in the sense that you still need consent, because there could be several ways of having access to the property right that maybe needed to be negotiated. And in my view, probably the Huawei decision somehow is going towards this direction. So, in a sense, distinguishing between bargaining power and market power.
Okay, I'm okay to take the first shot. So I think it's probably fair to say that DG.Com did not really welcome the Huawei judgments in spite of what it officially said. And this may have been the price to pay for basically rushing in the adoption of two decisions in Motorola and Samsung. Now, I think we're talking about two sets of maybe beliefs about FRAND, between the prevailing philosophy at the time in DG.Com and the prevailing philosophy at the Court of Justice in Luxembourg. And maybe a little more, maybe like what you would read in US legal scholarship, FRAND in DG.com's view was pretty much a sort of distributional problem, where you had to put a number, a metric on what is FRAND, what's unFRAND, and you could, like an economist would do, gauge a price level and some price metrics which would tell you whether it's FRAND or unFRAND. And that was, I think, sort of undergirding thinking in DG.com. The Court of Justice was, I think, more humble and said, you don't need to set metrics in stone for something to be FRAND. FRAND can be a best efforts, like pater familias or bona fide type of standard. It can remain flexible. And we have, in legislation and in the history of legal systems, and including informal legal systems, abundance of examples of soft commitments which have generated cooperation among strangers. Many of them in the medieval times, fair trades in Belgium, France, and Britain were governed by such sorts of informal commitments. And I think the court was willing to affirm this idea that you have here a set of behavioral principles which apply on both sides, and if you have a good framework, then the outcome should be appropriate. DG.com was much more out trying to drive outcomes and force outcomes on market players. I think the court said, we just need to create a process, much like in the economic literature on incomplete contracts. If you have a good process to solve contract incompleteness, then you will come up with optimal results. And I think this is the sort of philosophy that the court has expanded and explained in the judgments, as compared to the more micromanaging approach of DG.com, which would tell you, yeah, disclose you can, disclose you cannot, this price you can, this price you cannot, this methodology you can, this methodology you can't. And so the beauty of practicing law and looking at law in motion is that now the European Commission, not DG.com officially, is back on the hunting trail, trying to yet again push Huawei and explained that Huawei is full of gaps and you need more. So maybe we have this discussion again in 5 years.
Maybe less.
Maybe less.
Okay, I will introduction about what is the Chinese court thought about this problem. And I think that there is really a discussion about what is the nature of FRAND in China, and then different people hold different viewpoint of that. But nowadays, I think that the Chinese court try to accept that FRAND is a commitment that made by the patent owner on his own will. So the FRAND is just a basic trust is between the licensor and the licensee. It means that if the licensee negotiates on the good faith, the licensor will provoke, will just go on the negotiation with him. So that we think that the FRAND, the basic principle behind the FRAND is the principle of good faith, or we can see that is various distinctions from what the reasons from competition law. That is why the Chinese court now want to resolve the issuance of injunction problems and decide the FRAND royalties just under the framework of patent laws and contract law. And since there are only one antitrust case in China about SEP, so it is not so clear that what kind of the rules in the Chinese court will follow to deal with the competition disputes like that. But we can see that the agencies also list several factors that the agency should take into consideration when dealing with the SAP's cases. And maybe the court will take that for the instance like that. But it's also some days we also give some advice to the court that you should distinctions in the outcomes of the behavior that really do harm to the market. Yes, as the market powers problems, I also want to say it is my viewpoint that it's really hard to find out the evidence on the license market whether one has the market power. Maybe it is another approach to find out evidence on the downstream market. Why SAP is needed? Because it supports some function that is needed by the end product. And so the first step is to analyze that is whether such kind of function is needed by the product for the consumer. If this function can be removed out from that such kind of product, maybe it is not, it has the market power. And another thing is that whether the standard is the only choice to support such kind of function. If the answer is yes, maybe it will give more evidence to support the market powers that. And the third one is that whether the standard SAP's owners have the powers to shift in different situations. Because sometimes I think that market power is time limited. Because of the changing of the technologies or because of the changes of the market needs, maybe the situation will change. So the courts will be very careful to look out and see such kind of evidence and to draw the conclusion at the analysis of all these factors. Thank you.
A follow-up on that. So in the guidelines for the antitrust AML agencies that are being worked on the drafts, it seems like they adopt sort of a little bit of a watered-down version of the Huawei safe harbor. But is it applicable in China, given that in the Huawei case, in my understanding is Germany has more automatic injunctions, whereas U.S. and China, the judge actually uses discretion and considers public policy. So, or do we really need to second guess judges or make antitrust violations for judicial decisions?
I think that the Chinese court give the decisions case by case. So I do not think the Huawei's cases will give the safe harbor to the licensee. And we know that now the Chinese court held the viewpoint that the FRAND giving the requirement is both to the licensee and the licensor. The ones who wanted to get the FRAND license, you have to act first to be very in good faith. So we can see that in the guidelines of the Beijing High Court, it listed several actors, both to the licensee and the licensor. So it's really one to keep a balance between these two parties. So I do not think that the Chinese court is absolutely support such kind of safe harbor.
Yes, as to my understanding, in the civil law countries, which would include China, it's more or less an automatic remedy. If there's an infringement, injunctive relief is more or less automatic. It doesn't, but there is a way you can create a new rule, and it is applied in Germany in some cases. For instance, not in patent cases as well, trademark cases, where, for instance, you make an order that a company is not allowed to use its company name because it's a trademark infringement. Then from one day to the other, that would mean that they're out of the business so you give them a leeway. So you give them like 6 months or 1.5 years to change their name. And that's a question of proportionality. So the injunctive relief is also has to be proportional always. So, but that's something which is in the jurisprudence of the higher courts and can be found. It could be used in SVP cases also, where the injunctive relief is too hard a remedy, too strong a weapon. Let me just make one remark to the first point we were discussing about how to find out FRAND. From my understanding, I think the robot case in Seattle, it was defendant was Microsoft, and it was all about an Xbox. I don't know what you make use with this Xbox, but you probably all know. But it was a piece of technology in this Xbox which Microsoft needed. I don't know who was the plaintiff, but they both had ways of calculating the license, a fair and reasonable license, and both seemed to be, by first sight, okay. I mean, one was relating, I think, on the price per item, and the other one was relating on the resale price. Now, if you look at the resale price of a product like that, there may be 100 technologies in it, and maybe the one we talk about was only the very last one, which you needed. Okay. Then if you look at the resale price includes the price for the 99 or other technologies. So this brings up the price enormously. So the difference between the two approaches, Microsoft and the plaintiff, was Microsoft came up with about 2 or 3 million they would owe, and the plaintiff came up with 2 or 3 billion. Yeah, so it was by 1,000 the difference. So this is, I mean, if you take the resale price as a reference, then of course, with all the technology in it, you have to pay enormously because you have to pay a percentage of that technology as well. So that's the kind of question whether FRAND could, when you have some kind of rules about what FRAND is, I think it's quite clear that the resale price should never be the reference.
I think that's a great segue maybe to talk a little bit about comparable licenses and how the courts have looked at that. I think it's important for non-U.S. audience to know that the Robart case was a contract case and not a patent law case. In the U.S., the Federal Circuit has nationwide jurisdiction over patent cases and is sort of the, unless it, on the rare case it goes to our Supreme Court, is sort of the law of the land. And in that respect, the Erickson versus D-Link and other cases are more indicative of how we actually, what the law is for patent. And in that case, they talk about comparable licenses being, as the Federal Circuit has said for a long time, could be sort of the best evidence of market value. And so I know other courts across the world have have talked about this too. I'm interested to hear about comparable licenses, including on the end user device level.
Yes, I mean, in this case, you are already, I mean, in the specific question of trying to understand. So you are behind the idea of whether or not you have to give access, but just deciding what is the right price, for instance. And so, of course, from an economic point of view, and for instance, also in Italy, many courts, especially the courts in Milan, used to have this sort of cases brought before the court, and they have to assess. Normally, they hire an economic independent advisor, and the discussion then is on whether or not you can build some comparable which could be applied. Then, of course, first of all, one first criterion regards whether or not the patent owner is, for instance, vertically integrated or not. So whether or not you can have a sort of internal reference price relative to, for instance, giving the access to a competitor. Now, this is something that has been done in some cases that then have been closed with settlement. But in this respect, you need to make a distinction between comparable licenses, for instance, for similar products or for similar kind of transactions, for which at a certain point, using discretion, an economic independent advisor could say this is a fair price, with the idea of looking at the internal benchmark, for instance, of a vertically integrated company to understand what would be the cost internally sustained by the company. Because if you look at the cost, you are shifting in a dangerous way, in my respect, from the idea of a fair price that is going to pay the research and development costs behind the idea that is patented, and the cost of producing the patented input, which are two completely different stories. And so we need to have clearly in mind that when you look comparable in terms of cost of production, you could be in the wrong way, because many of the ideas that you are produced through a patent have a very low incremental costs. While when you are trying to fix a price for a patented input, probably you are going to fix a price that is going to give you some compensation for all the alternative projects that they have failed. So it's a different story. And my fear is that it could be that people used in regulation, for instance, used to apply pricing mechanism in regulation for utilities, for instance, or for vertically integrated firms in which the owner is the owner of an essential facility, could somehow apply that framework of setting prices to patents, which would be wrong, because in the previous case, all the economic structure in terms of pricing is based on long-run incremental costs or the cost of maintaining an infrastructure or whatever, which means that somehow you're just measuring really non-discrimination in terms of internal costs versus external costs. While in the case of patent, you need, when you define fair, you should not only look at the demand side, but also to the supply side. I mean, the compensation of the cost sustained in order to have the patent input to be introduced in the market.
So I think I've been listening to this discussion with great interest, and I think Commissioner Nichita, you mentioned that bargaining power can and shouldn't be confused with market power. And so I guess my question is the following, right? When people invest in technologies towards, contribute their technologies towards standards and license them, they have a certain incentive, and one of those incentives is to make that technology as available as possible to have as large a market as possible. I mean, that's the trade-off that you play as a business when you're trying to think whether to develop a proprietary technology or a standardized technology. Like the difference between, for example, having a small pool and having full ownership over that pool, so a proprietary type system, or enabling an ocean but having a very small part of that ocean, right? That's the sort of trade-off, strategic trade-off you're making as a business to determine which way to go. So maybe the bargaining power is increased, post-standards, but the question is, how do we take into account the incentives of the parties, with this bargaining power who are licensing, to make sure that the market continues to be large enough and broad enough and growing so that they continue to be benefiting from the larger access to a larger market and continue to grow.
Okay, thank you. When I'm saying that there is an increase in bargaining power, that's it, because economists know that there are games that are called bargaining games, for which the final results of the bargaining game depends on repeated interactions, knowing when the game will end up, the role of outside options. So when each party could say stop and get out, and so on and so forth. So having bargaining power in some cases simply means that you can make the final offer, or that you can exit a relationship, or that you can go before a court. Generally, it has to do with the abilities of having a given stake of a pie. Okay, but it does not mean that you will have the growing side of the pie. It depends on the rules within the bargaining game. But you raise an important question, which is what are the incentives? What are the incentives on the SEP owner side to inhibiting access to the SEP, since it has an interest in growing the potential demand, to exploit the bargaining power. So I agree with you, and this is the reason why, and I think Professor Padilla mentioned this, it depends whether you or your potential counterpart are or not vertically integrated. So if there is something missed in the relationship because there is some exclusionary intent upstream or downstream. If it is not, as in many cases, then it is true that potentially you should not have incentives just to deny access or refusal to deal, because for you it's just simply another contract that it's going to improve your position in the market. Somehow, in terms of antitrust, this is why I mentioned the aftermarket story. It is similar to refusal to deal and to all the literature between intra-brand and inter-brand competition, where somehow refusal to deal is simply motivated by defending the brand or defending the value of the investment in trademark. So it is based on efficiency reasons rather than exclusionary. Then another question, and I will stop, refers to repeated interaction, which has to do with the incentives to disclose the information when you are setting a standard. Because you can be opportunistic for once, but then since people around the table are always the same, it is not credible to become an opportunistic agent more than once. So somehow you have all the incentives to show that, you reveal the information when you have secret information, you want to build a standard. So these two incentives continue to providing the inputs to the demand, and repeated interactions, so for which you will be punished in the future if you behaved opportunistically in the past. I think there are two mechanisms that somehow provide endogenous enforcement mechanisms in this setting.
About 10 minutes left. If you have more questions, please raise your hand. I have one. You mentioned, Commissioner, about the hold-up literature, Oliver Williamson and Benjamin Klein, and the symmetrical nature of hold-up and then the holdout also. So, at least in the U.S., we've heard antitrust enforcers say that they're really only concerned with, for antitrust, one side of the holdup by patent holders, and that holdup by implementers is not an antitrust issue, although important for the overall balance in policy. I mean, if you're only looking at one side, does it upset the balance? And just thoughts on that.
This is precisely the point, because from one side of the story, having standardization is simply one way to grant right incentives for people who ask to invest and make specific investment that otherwise would not have been done in the first instance. So standardization in that literature, which has also been mentioned by Professor Sedek, means that you are simply providing safeguards for specific investment through standardization. So standardization is simply something that is granting that there will be a final demand for a specific investment, which is an investment that has a value only in that relationship. If you just take that investment outside in other alternatives, it has no value at all. So there has not been cases for hold up in contractual relationship or for safeguards against hold up. So at the same time, having hold up or having antitrust rules against potential hold up in SEP without any other connection with a dominant position or essential facility, market power, and so on and so forth, somehow is shifting antitrust into contractual rules. And this may somehow affect competition, because this is my last comment. I think that binding too much the behavior of SEP owners increase the incentives for potential infringers to infringe, because they know that they could infringe as a sort of rights to access. And so they have incentives to delay any agreement with the SEP owners, because they know that if the SEP owners would stop them, then it could be alleged of abuse of dominant position. So in a sense, binding the SEP's owner behavior could increase incentives for hold up on non-investors. So this is why I think the evolution toward Huawei is a positive one, and we will see whether there will be some adjustment in the future.
Yeah, sure. So we finished a paper recently with a colleague called Bowman Hayden, and we called the paper patent trespass instead of using the word holdout, because we actually realized that in the early literature on IP, holdout denotes the conduct that we today call hold up. But holdout is much less pejorative. It's a very well understood phenomenon in mainstream economics, things like eminent domain and property, land assembly issues and all that generated holdout problems. So we should have used that terminology, but some people decided to use hold up, which sounds more villain and malicious. And so to avoid sort of writing in that space and conveying that pejorative, loaded meaning in our paper, we decided to use an equally loaded concept as hold up, which is patent trespass, because trespass sounds very bad, much as hold up sounds very bad. Now in the paper we did a survey with a number of industry participants to understand the nature and magnitude of the problem of holdouts, and two things came up in that discussion. One is that trespassers, so the holdout players, they're not all the same. You may have large manufacturers with shops in every big city and products everywhere in the world. They operate in jurisdictions who abide by the rule of law. And what they do, this first category, they're basically trying to delay payments, right? Well, but at the end of the line, you can track them and find them and maybe bring them to pay you. The other category is really the more nefarious type of holdout firm. They just don't want to pay nothing, right? So they're going to hide and all that. So the second thing that we discovered in the paper is that, in fact, most of the revenue that SEP owners make, if they're subject to holdouts, is with the first category of people. So eventually, they will generate, the patents will generate payments and revenue. It will take some time. It's a hassle, transaction costs, and so on and so forth. Now, so we see in the paper there's sort of long tail where it's not much revenue. SMEs and firms located in very distant jurisdictions where you don't have remedies. So that represents a size which a SEP owner may rationally decide to turn a blind eye on and just not try to seek remedies against them. But now if you bring into the play the IoT and this licensing at all levels that we see in policy papers, then maybe this long tail, which represents a lot of companies but not much revenue, so maybe the amount of companies that we're talking about holding out will multiply by big factors, and the revenue will equally decrease by many factors if you have this regime of licensing to hold. So the concern, in other words, is if with IoT and under current policy, we are moving towards this licensing to hold thing where every and any small firm has to take a license, and you can't value that as much as you did on the large companies, and then also you need to correct for the large companies because they have to pay less because other licenses were taken. So the size and the revenue effect is a completely different equation, and the holdout or trespass problem becomes much more of another problem as well.
Well, this has been fascinating. We only have about 4 minutes left, so I did want to just ask about balance. We've heard a lot about balance today, and I wonder what that means. You know, Judge Ginsburg and Josh Wright have done work about the thriving nature of the mobile industry, that, you know, the evidence shows that prices are decreasing, innovation is increasing, concentration's going down. So do we want a balance where, you know, protecting that thriving market, the sort of status quo pre-IEEE revisions, or is there a new balance? I mean, so what does balance mean? Since we have a few minutes left, maybe everyone will just go down the panel a few minutes on what you mean by balance when you say it.
Okay, first of all, I think the balancing means that the two parties in the negotiations should have the same positions in negotiation. That is one kind of balance. Because we can see that nowadays, I want to say, once upon a time, people think that the hold up or hold out problem is very important because people want to find out the reason why you should set up special rules for sinking injunction. Because sinking injunction is, generally speaking, is not force right for the patent holder. And it's why you have to set up such a kind of special rules for the SEP holder. So also people want to find out the evidence from the holdout or hold up, like that. But now, when we see anything in the negotiations, we find that such kind of negotiation happens in two parties. Sometimes it is just the private dispute. So we can see that there is unwilling licensor or licensee. So the court want to give both duties to the two parties to keep the balance between them in the negotiation. See that both of them just bear the same duties to the negotiation in such kind of half is a good faith. So you can see that what is the kind of half information should be provided by the licensor, because he just know exactly what is needed for the negotiation. And also the licensee has to give also the offers of that, counter offer of that. So I think that kind of is a cause for those negotiations is a kind of needing to keep balances between these two parts. And another means of balancing is that you have to balance the competition and innovation. You know that the creators, they just involved on the innovation, and that will also do good for the consumer in the future. So maybe this time, when we talk about these things, we have to keep in mind that this balance is more important for the consumer. Okay.
Yeah, thank you. So I'll be very short. I think a lot of discussion has gone into discussing the lock-in effects on implementers and the fact that they have sunk investments into the standards. I think that should systematically, if you accept the idea of sunk investments, by logic, we should extend the discussion of sunk investments to the sunk investments of the technology developers. And so you're faced with a conflict between, say, two exit barriers, sunk investment of developer versus sunk investment of implementer. I don't know how to tilt the balance between the two of them, which interest, which investment should be favored over the other. But I'm just suggesting that in the context of general purpose technologies, which generates horizontally, vertically, and through time many externalities, maybe paying attention to the sunk investments of developers is not a bad idea.
Well, applying the law is always striking a balance, and all you do all the time is an analysis of interests and then balance the interests, and that's really what law finding is. So that's at the core of antitrust law as well.
That concludes our panel. I'm sorry if I didn't get to you with questions, but please come up to us afterwards and chat. Thank you. Please join me in thanking our panelists.